facing the police every single day.
Yeah, Michael, so if
11 local law enforcement calls it a crushing blow.
One of the most common tactics to crack down on illegal marijuana use is no longer an option, at least for now.
As WPTV News Channel 5's Megan McRoberts reports, in Martin County, the sheriff says the impact goes beyond drug arrest. Megan.
Yeah, Michael, so if a law enforcement officer pulls someone over and say they smell or even see something that they believe is medical marijuana or not medical marijuana, that used to be enough probable cause for them to go ahead and search the vehicle, but that is no longer the case now that legal hemp is so similar to illegal marijuana.
Nancy Tango 72.
Anytime deputies on patrol pull over a car, they're trained to know if there might be marijuana inside.
The fresh or burnt has a pretty distinct odor.
And the presumed smell or sight of it used to be one way deputies could ask to search a car without a warrant. But according to this letter from the state attorney's office, new laws taking hemp off of the controlled substance list will make marijuana searches and arrests more difficult.
And this agency and most agencies in Florida will not be making marijuana arrests.
Because according to the state attorney, legal hemp and illegal marijuana are identical in look and smell. The lab law enforcement uses to test possible illegal substances isn't yet equipped to detect illegal levels of THC.
Until we have a lab that can test, law enforcement efforts around marijuana are dead in the water.
Corporal Billy Jake says being able to use sight and smell of marijuana as probable cause to search often led to bigger discoveries.
Cannabis itself or other drugs or guns or other.
Those days are gone.
The state attorney says local labs might be updated in 3 to 6 months to test for THC, but until then,
we'll work around it. It will be a blow to everyday enforcement efforts, and society will not be better off for this.
So the sheriff says, though, this is still not a free ticket for someone to try to get away with illegal activity. Deputies can still do field tests to determine if someone is driving under the influence of an illegal substance simply by judging their behavior behind the wheel. Reporting live in Martin County, I'm Megan McRoberts, WPTV News Channel 5.
In a major win for freedom, Maryland's top court ruled this month that police can no longer stop people based on the smell of marijuana. Smell. Top court rules cops can no longer stop people after claiming to smell marijuana. Matt Agarist, August 19, 2019. Maryland. In case after infuriating case, the Free Thought Project has reported on instances of horrifying rights violations, all stemming from a police officer claiming to smell a plant. We have seen both women and men sodomized and raped, oftentimes in public, as cops search for the smell. We have seen entire families held hostage, women and children beaten up, rampant sexual assault, and all of it stemming from a plant smell. Apparently, the violence has gotten so out of hand that one top court in Maryland is doing something about it. The Court of Appeals of Maryland, the highest-ranking court in the state, said in a ruling this week, which opened by quoting Bob Dylan singing "The times they are a changin'," that police are not justified in searching a person based solely off of the smell of marijuana, according to a report in The Hill. The ruling was unanimous and common sense prevailed among all 7 judges. The ruling came from a case that unfolded in 2016 in which Michael Pacheco was searched and subsequently arrested because police claimed to smell weed in his car. As The Hill reports, during the incident, 2 officers, identified in court documents as Groger and Heffley, were conducting a routine foot patrol in Wheaton, MD, when they noticed Pacheco alone in a dark parking spot behind a laundromat, the court's 27-page opinion states. After growing suspicion of the idea of someone sitting in his or her car rather than in the laundromat, which was open at the time, the officers decided to approach the vehicle. Upon approaching Pacheco's car, the officers said that they smelled fresh burnt marijuana. Court documents said that shortly after, Heffley noticed a marijuana cigarette in the vehicle's center console, which he testified he knew immediately was less than 10 grams. Despite a 2014 law which decriminalized possession of marijuana of up to 10 grams, Police used the marijuana smell as justification for a warrantless search and subsequent arrest for both marijuana and cocaine, which police would later find. Pacheco would then go on to challenge the arrest as illegal, based on this unlawful search. Pacheco moved to suppress the cocaine, arguing that the officers' warrantless search of his person was illegal because, at the time of the search, the officers lacked probable cause to believe that he possessed 10 grams or more of marijuana, court documents state. The state countered that the odor provided probable cause to search both the vehicle and Mr. Pacheco. The lower courts did not agree with the suppression of the evidence, so Pacheco appealed it to the state's top court, and this month, he won. In the post-decriminalization era, the mere odor of marijuana coupled with possession of what is clearly less than 10 grams of marijuana, absent other circumstances, does not grant officers probable cause to effectuate an arrest and conduct a search incident thereto, the court stated in the ruling. It is well established that individuals have a heightened expectation of privacy in their person as compared to their automobile, meaning the probable cause analysis for the search incident to arrest exception versus the automobile exception will often differ given the respective justifications for those exceptions and the facts and circumstances of each case, it added. This ruling is a major boon for freedom and will only serve to improve police and citizen interactions by removing one of the ways police can harass individuals. Hopefully it will spread to other states. As TFTP reported in June, an infuriating video was shared with the Free Thought Project showing North Carolina cops violate the rights of multiple innocent people because one of them smelled marijuana. No marijuana was found, but that didn't stop cops from holding a family and their guests hostage for over an hour to look for it. Also in June, TFTP reported the case of Erica Reynolds, 37, who is seeking $12.5 million in damages, accusing police of sexual assault and battery, wrongful arrest, false imprisonment, gross negligence and intentional infliction of emotional distress. The reason for this sexual assault and battery? Cops smelled weed. Just last month, TFTP reported on another case in which Chanel Bates, 26, was leaving a restaurant when she was targeted by police who claimed they smelled marijuana. The officer's olfactory intuition was then used as the justification to detain, savagely beat, and kidnap the entirely innocent woman who had caused harm to no one. The infuriating and disturbing scene was captured on video. In the land of the free, cops will claim to smell a plant on you and use that claim to violate your body in the most horrific way. And some people still have the audacity to call this justice. Luckily, as this ruling in Maryland highlights, these people are becoming fewer by the minute.
Hey Sheriff County, this is Sheriff County COPWATCH. I am using any video here with under fair use if you have criticism, reporting, teaching, etc. And please donate. I do not make money from YouTube. And there are different ways to donate in the video links. Thanks.